Hey everyone, and welcome back to the Sleepless Dossier, the only place where history keeps you up at night. Today we're pulling the curtain back on one of the most foundational lies ever told, the myth of progress. We're sold a simple story, a straight line moving from the caves to the courtroom, from oppression to enlightenment. But the true history they don't want you to know is that the arc of the moral universe doesn't just bend toward justice. Sometimes it snaps backward with terrifying force. This isn't a feel-good story. It's a deeply uncomfortable look at how an entire civilization's legal framework could be buried, and how rights once held as fundamental could be systematically dismantled over centuries. Before we dive into the inevitable betrayals and double crosses, if you appreciate us digging up the facts that keep historians awake, please hit that like and subscribe. It ensures these secrets keep finding their way into the light. All right, dim the lights. This one gets messy. There is a story we tell ourselves, a comforting narrative whispered in classrooms and cemented in textbooks. It's the story of the upward climb. Humanity, it goes, started in the dark, ignorant, brutal, and chained by superstition, and has been steadily, inexorably, marching toward the light. Every century is an improvement on the last. Every new law is more just than the old one. We are, by definition, more enlightened than our ancestors. It's the grand organizing principle of the modern world, the ultimate justification for our own perceived superiority. It is also, and I cannot stress this enough, a complete and utter fabrication. It is a bedtime story told to a civilization that is terrified of admitting the truth, that progress is not guaranteed, that rights are not permanent, and that history is not a ladder, but a wheel. And the proof, the irrefutable damning evidence, lies in a simple, shocking comparison. Take a woman living in Thebes in 1200 BCE, during the height of the New Kingdom of Egypt. Then take a noblewoman living in Normandy in 1200 CE, at the heart of so-called Christendom. That's a gap of 24 centuries. 2,400 years of supposed progress, philosophy, art, and law. Yet the woman from the ancient world, the pagan from a civilization lost to dust, possessed more legal rights, more economic freedom, and more personal autonomy than her supposedly advanced medieval counterpart. This isn't a fringe theory or a controversial interpretation. It is a cold, hard fact, written on thousands of surviving papyrus scrolls, marriage contracts, divorce settlements, lawsuits, and property deeds. The lie of linear progress is shattered by this one inconvenient truth. The Egyptian woman could own, inherit, and dispose of property in her own name, without the oversight of any man. She could enter into legally binding contracts. She could sue and be sued in an open court, serve as a witness, and even sit on a jury. Upon marriage, she did not vanish into her husband's identity. She remained a separate legal entity, with her name, her wealth, and her rights fully intact. The medieval European woman, by contrast, was a ghost in the legal system. Upon marriage, she was consumed by the doctrine of coverture, her existence legally absorbed by her husband. She could not own property. She could not sign a contract. She could not sue. She was, for all intents and purposes, a legal minor, first under the thumb of her father, then her husband. She went from being a piece of one man's property to another's. This wasn't a gentle slide backward. It was a catastrophic collapse. A systematic, deliberate dismantling of female personhood, executed over centuries by empires and institutions that saw independent women as a threat to their power. The inconvenient reality is that the legal architecture of the enlightened West was built on a foundation that was fundamentally more restrictive for women than a system that had thrived 3,000 years earlier. To understand this is to understand that our history is not one of constant improvement, but of ideological wars where fundamental rights can be, and have been, a casualty. The architects of our modern historical narrative went to great lengths to ignore or explain away this reality. It was an aberration, a quirk of a strange sun-worshipping people. This dismissal is perfectly encapsulated in the private correspondence of the men who built the very field of history. Uncomfortable. Quote, from a letter by Sir Reginald Croft, a prominent 19th century historian, to a colleague at Oxford. We must be careful not to grant these Egyptian curiosities the weight of true legal tradition. To find that their women engaged in commerce or litigation is amusing, certainly, but it is the mark of an uncivilized society, one lacking the clear natural and divinely ordained separation of spheres that is the very bedrock of a stable Christian nation. Their system represents chaos. Ours represents order. And there you have it. The justification for erasure. It wasn't progress. It was a necessary correction. They saw the evidence, understood its implications, and chose to label it chaos to protect their own carefully constructed order. This is the core of the deception. The Great Regression was rebranded as the establishment of natural law. The theft of rights was called the dawn of civilization. The meta-commentary here is a stark warning. The most dangerous lies are the ones that flatter our sense of advancement. By believing that our world is inherently more just than the past, we become blind to the mechanisms that can drag it backward. We forget that freedom is not an inheritance. It is a fortress that must be defended constantly from those who would tear it down and convince us it was for our own good. The story of what happened between ancient Egypt and medieval Europe is not ancient history. It's a blueprint for how to lose a world. To understand how that world was lost, you first have to understand how it was built. The legal rights of Egyptian women were not an accident, nor were they the result of some forgotten wave of progressive social activism. They were a direct, logical consequence of the single most important concept in the entire Egyptian worldview: Ma'at. We often see Ma'at depicted as a goddess, the one with the ostrich feather on her head, and we reduce her to a simple symbol of truth or justice. But that's a dangerously simplistic translation. Ma'at was not just a deity. It was a fundamental cosmic principle. It was the force of order, balance, and righteousness that the gods themselves had established at the moment of creation. Ma'at was the opposite of Isfet: chaos, injustice, and the lie. For the universe to function, for the Nile to flood, for the sun to rise, Ma'at had to be actively maintained in the heavens and on earth. And this is the critical point. For the Egyptians, the courtroom was not just a place to resolve petty human disputes. It was a front line in the eternal war between order and chaos. Every legal decision, every verdict was an act that either strengthened Ma'at or allowed Isfet to creep into the world. This wasn't a metaphor. It was judicial philosophy. The vizier, the highest official under the pharaoh, wasn't just a prime minister. He was the high priest of Ma'at. His primary duty was to do Ma'at, to ensure the law was applied with perfect impartiality. Because if the law became imbalanced, the entire cosmos could follow. Within this framework, the idea of excluding an entire half of the population from the legal system was not just unfair, it was cosmically insane. It would be like a farmer choosing to plant only half his field. You would be willfully creating imbalance, actively inviting chaos into your society. A woman's testimony in court, her right to own property, her ability to sue her neighbor, these weren't granted as a social courtesy. They were essential data points required to find the truth and maintain the cosmic balance. Her legal personhood was a non-negotiable component of a functioning universe. To deny her a voice was to create a void, a pocket of injustice where the forces of Isfet could fester and grow. This is why, when you read Egyptian court documents, you find a startling lack of gendered language. The law refers to any person or the petitioner. The system did not care if you were a man or a woman. It only cared about the facts of the case and whether your plea was in alignment with Ma'at. This stands in stark, brutal contrast to the legal systems that would eventually replace it. Greco-Roman law, and later medieval European law, was built on hierarchy, on the power of the paterfamilias, the male head of household, on the divine right of kings, on a God who was explicitly gendered male and whose chosen representatives on earth were all men. Order in these new systems was not about balance. It was about submission to a rigid patriarchal structure. Justice was not a cosmic principle to be upheld, but a privilege dispensed from the top down. The foundational text of the Egyptian legal system, the training documents for young scribes and officials, reveal this starkly different operating system for society. They are not filled with flowery language about rights, but with grimly practical warnings about the consequences of injustice. Classified memo. From the Instructions of the Vizier, a real text outlining the duties of the office, circa 1500 BCE. When a petitioner comes from Upper or Lower Egypt, see to it that all is done according to the law, that all is done according to the custom thereof, giving to every man his right. Do not distinguish the great from the humble. A judge must be the rudder that guides the ship of state. If he falters, the whole vessel founders. Remember that the abomination of the god is partiality. There it is, laid bare. Giving to every man his right, where man in the Egyptian context meant human or person. Partiality, favoring the rich over the poor or the man over the woman, was not just a crime against society. It was an abomination of the god. It was spitting in the face of creation. The long-term consequence of abandoning this philosophy was catastrophic. When a legal system is based on an abstract cosmic principle of balance like ma'at, it is inherently flexible and resilient. It can, in theory, apply to anyone. But when a legal system is based on the inherent superiority of a specific group, men, aristocrats, clergy, it becomes a rigid cage. It is no longer a tool for discovering truth, but a weapon for enforcing a power structure. The shift from one to the other wasn't just a change in laws. It was a downgrading of the entire concept of justice. And it was this philosophical poison that would allow for the complete and total legal subjugation of women in the centuries to come. The first chain was forged the moment justice ceased to be a universal requirement and became a gift from a powerful few. That first chain, the one that anchors all the others, is often the hardest to see. It's not forged in the dramatic fire of a new law or a royal decree. It's slipped into place quietly, through custom, through language, through something so seemingly innocuous that no one recognizes it as a weapon until it's too late. For the women of post-Egyptian civilizations, that first fundamental chain was the theft of their name. In our modern world, we see a woman taking her husband's name as a tradition, a romantic gesture. But its origins are neither romantic nor benign. It is the ghost of a legal doctrine, a quiet bureaucratic violence that accomplished what no army could: the complete erasure of a woman as an independent entity. In ancient Egypt, a woman's identity was her own. It was absolute and non-negotiable. When she was born, she was given a name: Neferu, daughter of Anku. That was who she was. It was her legal designation, her link to her lineage, her mark upon the world. And when she married, she remained Neferu, daughter of Anku. Her husband did not bestow his name upon her like a title. He did not absorb her identity into his own. She entered his house, but she did not cease to be herself. Her legal personhood, anchored by her own name, was immutable. This wasn't just a quaint custom. It was the bedrock of her autonomy. Because she kept her name, she kept the legal trail to her property. The land she inherited from her father remained tied to Neferu, daughter of Anku. The business she ran was registered under her name. If she signed a contract or sued a debtor, she did so under her own identity. She was a fixed point in the legal and economic landscape, visible and accounted for. Now, contrast this with the system that systematically replaced it. The legal tradition that would eventually dominate Europe performed a kind of magic trick, a sleight of hand that made half the population disappear. Through the doctrine of coverture, a woman's legal identity was not just altered by marriage, it was extinguished. Jane Smith, an independent person, married John Doe and legally became John Doe. She was Mrs. John Doe, a possessive, an attachment. She ceased to be a noun and became an adjective. The law from that moment forward no longer saw Jane Smith. It saw a wife, an extension of the husband's will, a creature whose actions, property, and even body were under his authority. It was identity theft on a civilizational scale, sanctioned by both God and the state. This legal death was not a bug in the system. It was the system's core feature. It was designed to consolidate property and power into the hands of men. By erasing the woman's name, the law automatically rerouted her entire economic existence. The inheritance she brought into the marriage was no longer hers. It was now managed and controlled by her husband. The wages she might earn were legally his. She could not accumulate wealth because she, in the eyes of the law, no longer had the capacity to own anything. She had become a legal shadow. The precision of this erasure is captured in the very language of ancient Egyptian marriage contracts, which read like documents from a different reality. Classified memo. From a marriage settlement inscribed on a limestone ostracon, Thebes, circa 1180 BCE. An agreement made by the scribe Amenhotep for his daughter, Anuk, and the stonemason, Kenna. The woman Anuk enters the house of Kenna. The property she brings from her father's house, namely 4 goats, 1 chest of linen, and 5 vessels of oil, remains her property forever. Any property they acquire together during their union shall be divided into 3 parts. She shall have 1, he shall have 1, and their children shall have the 3rd. She enters his house as a partner, not as a servant. Her name is Anuk, and by her name she shall conduct all her affairs. The meta-commentary here writes itself, in stark and brutal clarity. The loss of a name was the primary mechanism for the loss of everything else. It was the master key that unlocked a woman's wealth and handed it to her husband. It's a far more insidious form of control than outright violence. It's control through bureaucracy. By rendering a woman legally invisible, the system made it impossible for her to build, to own, to fight. How can you file a lawsuit when you have no legal name? How can you claim ownership of land when the deed must be in a man's name? You can't. The game is rigged from the very first move. The tradition of a shared name, which we are told is a symbol of unity, was in fact the instrument of a great and silent theft, repeated millions of times over centuries. It was the legal equivalent of wiping a person's name from the public record, ensuring that for all of history it would be as if she had never truly been there at all. And with a name comes a voice the law is obligated to hear. This is the next pillar to fall, the next freedom to be systematically erased from the collective memory of civilization. In the world we have inherited, the image of the courtroom is overwhelmingly male. Male judges, male lawyers, male defendants. The woman is an accessory, a spectator, a victim, but rarely the agent. This is not an accident of history. It is the result of a deliberate and successful campaign to mute half of humanity. But on the dusty banks of the Nile, the scene was radically different. To the ancient Egyptian mind, a courtroom without women would have been as absurd as a temple without priests. It would have been an incomplete circuit, incapable of channeling the power of Ma'at. Surviving court records, scribbled on fragments of pottery and papyrus scrolls, paint a picture that is, to the modern eye, shockingly egalitarian. They reveal women not as passive observers, but as dynamic and often ferocious legal actors. An Egyptian woman could walk into a kenbet, the local council of elders that served as a court, and initiate a lawsuit against anyone. A neighbor who failed to repay a loan of grain, a merchant who delivered faulty goods, even her own husband or father if they violated a contract. She stood before the judges, stated her case, and presented her evidence. There was no requirement for a male guardian to speak for her, no legal fiction that deemed her incapable of representing her own interests. Her right to demand justice was as fundamental as a man's. This extended to her role as a defendant. Because she could sign her own contracts, she was legally bound by them. She could be sued, and she was expected to answer for her own actions. This wasn't a punishment, it was the other side of autonomy. It affirmed that she was a fully accountable member of society, not a child to be protected from her own decisions. Perhaps most critically, a woman could serve as a witness, and her testimony carried the same legal weight as a man's. Again, this was a matter of cosmic pragmatism. The court's function was to uncover the truth, to restore balance. To arbitrarily decide that the testimony of half the population was inherently less valuable would be to willingly blind oneself. It was an act of self-sabotage, an invitation to injustice. Now transport yourself forward 2.5 millennia. To a stone courtroom in feudal England or France. A woman who has been wronged cannot speak. The law, in its infinite patriarchal wisdom, has decided her voice is unreliable, her emotions too volatile, her intellect too feeble. To make a claim, she needs a man to do it for her, her husband, her father, her brother. She stands silently while he pleads her case, her legal existence filtered through his voice. If her testimony as a witness is even permitted, it is often devalued. with some legal traditions requiring the word of 2 or 3 women to equal that of a single man. She is no longer an agent in the pursuit of justice. She is a piece of evidence, to be presented and interpreted by men. The system has been re-engineered not to find the truth, but to uphold a hierarchy. The raw fury of Egyptian women who felt cheated comes through with startling clarity in the surviving legal pleas. They are not demure or submissive. They are demanding, precise, and confident in their right to be heard. Uncomfortable, quote, from a plea inscribed on a papyrus from the village of Deir el-Medina, circa 1150 BCE, spoken by a woman named Haria. I am Haria, daughter of Webket. I bring this charge against the weaver Pentu. He took possession of the donkey that was willed to me by my mother, a free woman of this village. I have my mother's testament, witnessed by 3 men of the Kenbit. I demand the return of my property and compensation for the work I could not do. I speak with my own mouth. I require no man to speak for me, for my cause is just and my voice is my own. The meta-commentary is a chilling diagnosis of a sickness that still infects us. When you systematically remove women from the legal process, you do more than just silence individuals. You fundamentally corrupt the concept of justice. It ceases to be a universal principle and becomes a tool used by one group to control another. You create a legally protected class of predators and a legally silenced class of victims. The long-term consequence is the normalization of the idea that a woman's experience of reality is inherently less valid than a man's, that her word is suspect, her memory flawed, her perspective biased. This legal principle, that a woman is an unreliable witness to her own life, escaped the courtroom and became a cultural cancer. It is the root of every time a woman's testimony has been dismissed, every time she has been told she is overreacting, every time she has been asked, "Are you sure that's what happened?" It began as a legal doctrine, but it became a way of seeing the world. A world where the truth, by definition, had a male voice. A voice in the courtroom is a powerful weapon, but only if it has something to defend. A right is meaningless if it exists in a vacuum. The legal voice granted to Egyptian women was not a theoretical abstraction. It was the shield that protected the most tangible and potent form of power in any society, ancient or modern: wealth. Economic independence is the bedrock of all other freedoms. The ability to earn, to own, and to control property is what separates a free citizen from a dependent. And it was in this arena, the cold, hard calculus of assets and ownership, that the women of Egypt enjoyed a level of autonomy that would become unthinkable for the next 3,000 years. The story of their economic annihilation is the story of a silent coup, conducted not with swords, but with marriage contracts and inheritance laws. In ancient Egypt, property rights were not gendered. The law recognized a simple principle. The owner of a thing was the person whose name was on the deed. Full stop. A woman could inherit land, livestock, servants, houses, and businesses from her parents, often on equal terms with her brothers. She could also inherit from her husband upon his death. This property was not held in trust for her by a male relative. It was not managed by her husband, it was hers, absolutely and unconditionally. Her name was on the papyrus scroll that served as the title, and with that came the absolute right to control it. She could collect rent from tenant farmers on her land. She could sell that land to the highest bidder. She could mortgage it, trade it, or, most importantly, she could pass it on to whomever she saw fit in her own last will and testament. This created something that the later patriarchal systems of Europe were specifically designed to prevent: independent female centers of economic power. A wealthy widow was not a helpless creature dependent on the charity of her male relatives. She was a formidable player in the local economy, a matriarch who controlled the fortunes of her family and her community. Women, in their own right, could become dynastic founders, accumulating and passing down wealth through female lines for generations. This wasn't a rare exception. The legal framework made it an ordinary feature of society. Now witness the demolition. The legal systems of Greece, Rome, and eventually medieval Europe viewed this arrangement as a fundamental threat to social order. Their entire economic and political structure was based on the consolidation of property in the hands of men. So they introduced a series of legal weapons to dismantle female ownership. First, they corrupted inheritance. Laws of primogeniture ensured that land, the primary source of wealth, passed exclusively from father to eldest son. A daughter might receive a dowry, a one-time payment of movable goods or money, but she was cut off from the generational transfer of real power. Second, they weaponized marriage. Through coverture, that dowry, and any other property a woman might possess, immediately fell under the complete control of her husband. She was a conduit, not an owner. Her economic life was a brief flicker between the authority of her father and the authority of her husband. The ultimate proof of this theft lies in the wills. An Egyptian woman's will was a document of immense personal power, where she acted as the ultimate arbiter of her family's future. The most famous example is that of a woman named Naunakte, who lived around 1150 BCE. Her will is not a gentle document, it is a blade. Uncomfortable, quote, from the last will and testament of the Lady Naunakte, discovered at Deir el-Medina. As for me, I am a free woman of the land of Pharaoh. I raised these 8 children and gave them all that was proper for their station. But see, I have grown old, and they do not look after me in my turn. Therefore, concerning the property I have acquired, my 4 children who have cared for me shall have it. The other 4 shall have no share whatsoever in my goods. They who have stood by me will be rewarded. They who have abandoned me will receive nothing from my hand. I have spoken. This is not the voice of a legal minor. This is the voice of a CEO, a matriarch, a queen ruling her own small kingdom. The meta-commentary here is a lesson in control. To control a population, you don't need armies in the streets if you can control their ability to earn a living. By systematically stripping women of the right to own and control property, the architects of the new order made them permanently dependent. A woman's survival now relied on her attachment to a man, father, husband, son. Her value was no longer in what she could build, but in what she could offer a man in a marriage alliance. This economic neutering was the single most effective act of subjugation in history. It created a permanent underclass, a population of dependents who could not fight back because they could not afford to. They had been silenced in the courtroom, yes, but first they had been bankrupted. The myth of the domestic sphere is one of the most resilient lies ever constructed. It's the idea baked into the bedrock of Western civilization that a woman's natural place is within the 4 walls of her home, managing the household while the man engages with the real world of commerce and politics. It's presented as a biological reality, an immutable truth of human society. But like the myth of progress, it is a politically motivated invention, and the evidence of its fraudulence is overwhelming. The ancient Egyptians would have found the concept utterly bizarre. For them, the line between home and the economy was not a wall, but a permeable membrane. And women were not confined by it. They moved through it with an ease and authority that would later be branded as unnatural, ungodly, and illegal. Far from being sequestered, Egyptian women were vital and visible players in the marketplace. This wasn't just informal, under-the-table bartering. They were entrepreneurs in the truest sense of the word, managing legally recognized businesses and controlling significant sectors of the economy. One of the most common and lucrative trades for women was brewing and baking. Beer and bread were the staples of the Egyptian diet, the very currency of wages for laborers, and it was women who overwhelmingly controlled their production and sale, running bakeries and taverns that were central hubs of community life. Another major industry dominated by women was textile production. From humble households to vast temple workshops, women were the weavers and merchants of the linen that was Egypt's most famous export. But their economic activity went far beyond these traditional crafts. Remember the property rights we just discussed? They were not theoretical. Women who inherited land acted as landlords, leasing fields to tenant farmers and collecting the profits. They bought and sold real estate, flipping houses for a profit in the bustling suburbs of Thebes. They acted as lenders, providing seed money, grain, or silver to their neighbors, at interest, and using the courts to collect from anyone who defaulted. They were active, calculating participants at every level of the economy. And the ultimate proof, The mechanism that made all of this possible was the contract. An Egyptian woman could draft, negotiate, and affix her seal to a legally binding agreement. This is the absolute litmus test of economic personhood. She did not need her husband's permission. She did not need a male relative to co-sign. Her word, her seal, was her bond, and the state would enforce it. These weren't rare occurrences. Surviving papyri are littered with contracts entered into by women from all social classes, from the wife of the vizier to a humble water carrier on the outskirts of town. Now, watch as the doors are slammed shut, one by one. The emerging medieval European order saw this kind of female economic agency not just as strange, but as a dangerous corruption of the social fabric. The guild system, which controlled all skilled trades from carpentry to goldsmithing, was the primary weapon. Guild charters were explicitly written to exclude women. They were forbidden from becoming apprentices, from attaining the rank of master, and therefore from legally practicing a skilled trade. This systematically pushed women out of the lucrative sectors of the economy and into low-paid, unregulated work like spinning or alewifing, and even in those areas, they faced increasing restrictions. The independent female merchant of Egypt was replaced by the marginalized alewife of England, a figure constantly harassed by local authorities and viewed with suspicion. The transactional, business-like nature of women's work is laid bare in the countless receipts and contracts that were part of daily life. These are not fancy royal decrees. They are the boring, bureaucratic proof of a world where a woman's business was just business. Classified memo. From a receipt written on a pottery shard, Deir el-Medina, circa 1250 BCE, the year 4, fourth month of the inundation, day 25. The scribe Amenecht, son of Ipui, has received from the woman Iritnefret 1 sack of barley. In exchange, he will deliver to her 1 painted casket by the first month of the harvest. He has stated this in the presence of the witness Nacht. If he fails to deliver, he will owe her 2 sacks of barley as a fine. He has sworn an oath by the life of the pharaoh. The meta-commentary is a stark reminder of the cost of wasted potential. By legally barring women from the marketplace, these later societies didn't just oppress women, they lobotomized their own economies. They willingly discarded the talent, the ambition, and the intellect of half their population. This economic exclusion then became a self-fulfilling prophecy. After centuries of being legally prevented from participating in commerce, the lie could be sold that women were simply not good at business. Their absence from the marketplace was presented not as the result of a deliberate policy of exclusion, but as evidence of their natural incompetence. The vibrant entrepreneurial energy of women like Iritnefret was not just suppressed. The historical record was rewritten to pretend it had never existed in the first place. If the independent female entrepreneur was a threat to the patriarchal order, then the independent wife was an existential one. Because it is in the institution of marriage that a society reveals its true intentions for its women. Is it a partnership, or is it a prison? Is it a contract between equals, or is it a ceremony of surrender? For centuries we have been sold the romantic ideal of marriage, a holy union, a sacred vow, a mystical joining of 2 souls. This is a beautiful story. It is also a carefully crafted piece of propaganda, designed to obscure the institution's true historical function as a mechanism of property transfer and social control. The ancient Egyptians were not so sentimental. For them, marriage was not a sacrament. It was a business deal. And it was a deal where the woman often came to the table with a better lawyer. There were no grand temple ceremonies for an Egyptian wedding. No priest sanctified the union. A marriage became official when the bride moved her belongings into her husband's house. That's it. It was a purely secular, civil arrangement, and because it was a civil arrangement, it was governed by a civil contract. These marriage contracts are among the most revolutionary and revealing documents in human history. They were not poetic declarations of love. They were hard-nosed legal agreements, negotiated often fiercely by the bride or her family, designed to protect her interests and secure her financial future with a cold, clear-eyed pragmatism that would make a modern divorce attorney weep with admiration. The standard Egyptian marriage contract contained clauses that were nothing less than a fortress around the wife's autonomy. First, it meticulously cataloged the shirkat, the property the wife brought into the marriage from her father's house. This property, the contract stipulated, remained hers and hers alone. It was not to be commingled. It could not be sold by the husband. It was her private capital, her safety net. Second, the contract laid out, in excruciating detail, what would happen in the event of a divorce. Typically, it stipulated that the husband had to immediately return the entirety of her dowry. No excuses, no delays. But here's the masterstroke, the clause that reveals the sheer legal sophistication of these women. Most contracts included what is essentially a massive penalty for the husband if he chose to initiate the divorce. He would be required to pay his ex-wife a huge lump sum, often equivalent to years of his salary, or pledge to pay her a monthly annuity of grain and silver for the rest of her life. This was not alimony in the modern sense. It was a contractual punishment. It was a poison pill designed to make divorcing his wife such a financially catastrophic decision that he would not dare to do so lightly. And finally, the contract specified how any property acquired during the marriage would be divided. The standard split was 1/3 for the wife, 1/3 for the husband, and 1/3 for the children. She was legally entitled to her share of the wealth she helped create. This was the deal. A woman entered a marriage not as a subordinate, but as a protected business partner with a rock-solid exit strategy. Classified memo from a Ptolemaic-era marriage contract, a later example showing how these traditions persisted, circa 200 BCE. The scribe Thoth-Hotep takes the woman Arsinoe as wife. She has brought to him a dowry of 10 pieces of silver and a chest of fine linen. This property remains the property of Arsinoe alone. If Thoth-Hotep should divorce Arsinoe for any reason, or if he should take another wife besides Arsinoe, he shall pay to her 50 pieces of silver as penalty and return her dowry in full within 30 days. Furthermore, all property we acquire from this day forward shall belong to our children, but she, Arsinoe, shall be the mistress of it all, with the power to do with it as she pleases, until her death. The meta-commentary here is a diagnosis of the great historical bait and switch. The move to transform marriage from a secular contract into a holy sacrament, controlled by the church, was perhaps the most brilliant and devastating act of legal warfare ever waged against women. By declaring marriage an unbreakable vow made before God, the new order achieved several things at once. It stripped away the woman's power to negotiate her terms. There are no clauses in a sacrament. You accept the terms as God has dictated them, terms of course written by men. It erased her exit strategy. An unhappy or abusive marriage was no longer a bad contract to be dissolved. It was a divine trial to be endured, often until death. It removed the state's role as a neutral arbiter and replaced it with a religious institution whose entire doctrine was based on female submission. The cage was locked, the key was given to God, and women were told that their imprisonment was a holy blessing. The ultimate test of freedom is not how you enter an arrangement, but whether you are allowed to leave it. A contract you cannot exit is not a contract. It is a cage. A promise you cannot break, no matter how toxic it becomes, is not a vow. It is a life sentence. The architects of the medieval world understood this with chilling clarity. They took the civil agreement of marriage and wrapped it in the divine chains of sacrament, creating an institution that was, for women, functionally inescapable. Divorce was not just a legal difficulty. It was a sin, a crime against God, a tear in the fabric of holy order. But this too was a radical and regressive invention. For the ancient Egyptians, the end of a marriage was as secular and pragmatic as its beginning, and the power to initiate that end was placed with astonishing equality in the hands of both the husband and the wife. An Egyptian woman who wanted to end her marriage did not have to petition a court, plead her case before a priest, or prove she was the victim of some unbearable cruelty. She simply had to declare it. The most common formula for divorce found in countless documents was stunning in its simplicity. A spouse would stand before witnesses and say, "I divorce you." Or in a more formal setting, they might issue a written deed of repudiation. Often the act of divorce was even simpler. The woman would just pack up her things and move out of her husband's house and back to her father's. That was it. The act of leaving was the legal statement. The contract was dissolved. This was a no-fault system, a concept our enlightened modern legal codes only began to grapple with in the late 20th century. A woman did not need a reason. She didn't have to prove adultery, abuse, or neglect. The fact that she no longer wished to be married was reason enough. Her will was sovereign. Her desire to be free was, in and of itself, legally sufficient. This is an almost incomprehensibly radical idea when measured against the 2,500 years of history that followed. It acknowledges a woman as a fully autonomous being, the sole author of her own life, with the right to erase a mistake or walk away from a future she does not want. But this right would have been a hollow gesture without the economic power to back it up. A right you cannot afford to exercise is not a right at all. This is where the genius of the Egyptian marriage contract revealed its true power. The moment a woman declared herself divorced, the exit clauses of the contract were triggered with the force of law. Her husband was legally obligated to immediately return the entirety of her dowry, every last pot, every last thread of linen. This was her severance package, her seed money for a new life. Then she was entitled to her share, typically 1/3, of all the property they had accumulated together during the marriage. This wasn't a matter for negotiation, it was her legal due. This financial security is what transformed the right to divorce from a theoretical possibility into a practical, viable escape hatch. The legal language used in these documents is not emotional. It is the cold, hard language of a business dissolution. It is about a clean break and a fair division of assets. Uncomfortable. Quote, from a deed of repudiation written by a husband to his departing wife, circa 360 BCE. I have abandoned you as wife. I am removed from you. I have no claim on earth upon you. Take for yourself a husband in any place you may go. I shall not be able to stand in your way from this day forward. The children are yours. I will provide their nourishment. Your dowry of silver and grain is returned to you in full, and your share of our joint property is set aside for you. Go and be at peace. The meta-commentary is a brutal indictment of the system that replaced this one. By making marriage an indissoluble sacrament, the church did not create stable, happy families. It created millions of private prisons. It trapped women with abusive husbands. It chained them to misery, and it called their suffering a holy duty. The argument was always about stability, about the sanctity of the family, but it was a lie. The true purpose was control. An inescapable institution guarantees a permanent power imbalance. By removing a woman's exit strategy, the system removed her leverage. She could not demand better treatment. She could not protest infidelity. She had no cards left to play. Her only choice was submission because the alternative was social and economic ruin and eternal damnation. The criminalization of walking away was the final lock on the cage, ensuring that once a woman entered the state of matrimony, she ceased to be a free citizen and became permanent property. If you design a cage to hold a tiger, you build it with iron bars and thick locks. But if you want to cage an idea, you do something far more insidious. You convince everyone that tigers cannot exist in the first place. You rewrite the books of biology to exclude them. You erase their footprints from the fossil record. You build a world so devoid of them that the very concept of a great cat becomes a myth, a fairy tale. For centuries, the patriarchal systems of Europe did exactly this. They built a world where the idea of a woman holding ultimate sovereign power was not just illegal. It was presented as a violation of natural law, a laughable absurdity. But the historical record contains a ghost that haunts this entire construction, a roaring refutation of the lie, the pharaoh Hatshepsut. Her story is often told as a bizarre exception, a freak occurrence, a woman who played king for a couple of decades. This is a deliberate misreading of history. Hatshepsut was not an exception to the Egyptian system. She was its ultimate proof. She was the logical, if extreme, conclusion of a legal framework that recognized a woman's right to own, to rule, and to act. Her reign was not a coup in the traditional sense. It was a masterful, audacious, and entirely legal campaign of self-promotion, using the very laws of the land to achieve what was previously unimaginable. She was the daughter of a pharaoh, Thutmose III, and the wife of her half-brother, Thutmose II. When he died, the throne passed to his infant son by a lesser wife, Thutmose III. Hatshepsut, as the dowager queen and the boy's aunt, was appointed regent. This was standard practice. But Hatshepsut was not a standard woman. For several years she ruled as regent, the power behind the throne. But then she did something unprecedented. She did not usurp the boy king or have him killed. Instead, she simply declared herself co-ruler, and then senior ruler, pharaoh. She marshaled theological arguments, claiming the god Amun-Ra had ordained her rule. She used her immense personal wealth, legally her own, to finance propaganda campaigns and building projects that cemented her authority. Most famously, she adopted the full five-fold titulary of a king and had herself depicted in the masculine iconography of power, the bare chest, the short kilt, the false beard. This wasn't a sign of gender confusion. It was a stroke of political genius. She understood that the symbols of power were a language. To be recognized as king, she had to speak it fluently. So she did. The most crucial point is this: the system allowed it. The priests, the generals, the viziers, they all went along with it. There was no civil war. The state did not collapse. Why? Because there was no law that explicitly stated a woman could not be pharaoh. The system was built on legal personhood, not on gender. And so, while her move was shocking and audacious, it was not, strictly speaking, illegal. She stress-tested the framework to its absolute limit, and the framework held. She ruled for over 2 decades, a period of immense peace and prosperity. She was not a placeholder. She was one of the most successful pharaohs of the 18th dynasty. Imagine trying to explain this to a baron in 14th century England. A woman as God's anointed king? The idea would have been grounds for a heresy trial. A woman's rule was so inconceivable that it required a new, lesser title, Queen Regnant. And even then, it was always seen as a weakness, a problem to be solved by marriage. Hatshepsut did not need a husband to validate her rule. She was the rule. Uncomfortable. Quote, from the private journal of a fictionalized high priest of Amun-Ra at Karnak, circa 1475 BCE. The regent has now declared herself king of Upper and Lower Egypt. The courtiers whisper. The generals are silent. It is an irregularity, a disruption of the established way. And yet, the law is silent on the matter. Her bloodline is pure, her command of the state is firm, and the offerings to the gods have never been richer. Ma'at is about balance, not tradition. Perhaps this is a new balance, one we do not yet understand. Or perhaps it is a test, for now we will serve the pharaoh. Her name is Hatshepsut. The meta-commentary is about the deliberate foreclosure of possibility. The later patriarchal systems were not merely designed to keep women out of power. They were designed to make the very idea of a woman in power seem like a cosmic joke. The tragic epilogue to Hatshepsut's story proves the point. Decades after her death, her successor, Thutmose III, began a systematic campaign to erase her from history. Her statues were torn down, her name was chiseled from monuments, her image was scraped from temple walls. This was not just personal animosity. It was an ideological cleansing. It was a recognition that her reign was a dangerous precedent. It proved that a woman could do the job of a king just as well, if not better, than a man. It was a truth so dangerous that it had to be buried, literally, under tons of stone and sand, to ensure no woman would ever get the same idea again. The world that followed wasn't just a world without female pharaohs. It was a world that had been violently re-engineered to make sure such a thing could never even be attempted. For nearly 3,000 years, the Egyptian legal system, for all its flaws, had remained a remarkably self-contained and resilient ecosystem. It was an island of female legal personhood in a world that was slowly drifting in the opposite direction. But in 332 BCE, the island was breached. The invasion did not come with fire and sword alone, but with something far more permanent: a new set of laws, a new language of power, and a new, fundamentally patriarchal worldview. When Alexander the Great marched into Egypt, he wasn't just a conqueror, he was a carrier. He and the Greek dynasty that followed him, the Ptolemies, introduced a legal virus into the Egyptian bloodstream, a Hellenistic contagion that would begin the slow, inexorable process of corroding the native traditions that had protected women for millennia. The Greek legal system was built on a concept that was utterly alien to the Egyptian mind: the Kyrios. In Greek law, a woman never reached legal majority. She was a perpetual minor, and from birth to death she was legally required to have a male guardian, the Kyrios. First, it was her father. Then, upon marriage, that authority was transferred to her husband. If she was widowed, it passed to her son or another male relative. Without the approval and signature of her Kyrios, a woman could not enter into any significant contract. She could not sell property, and she could not represent herself in court. She was, in the eyes of the law, a child, a creature incapable of rational decision-making, whose will had to be filtered through the superior intellect of a man. When the Ptolemies established their rule in Alexandria, they did not immediately abolish Egyptian law. That would have been impractical and would have sparked massive rebellion. Instead, they created a two-tiered system. The new Greek elite, the soldiers, administrators, and merchants, would live under their familiar Greek laws. The vast native Egyptian population could, for the most part, continue to use their own courts and customs. On the surface, this looks like tolerance. In reality, it was the creation of a legal apartheid, and the laws of the ruling class always bleed downwards. The contamination began in the centers of power and commerce. An Egyptian woman who owned a successful weaving business might find that to secure a lucrative contract with a Greek shipping merchant, she was now expected to have her husband co-sign the agreement. The Greek official would not recognize a contract signed by a woman alone. It was invalid under his law. To get ahead, to interact with the new power structure, Egyptian women were increasingly forced to play by the Greek rules. They had to adopt the legal fiction of male guardianship, even if it had no basis in their own traditions. The path of least resistance, the path to wealth and influence, was now paved with patriarchal procedures. The old system wasn't outlawed. It was simply made increasingly inconvenient, inefficient, and irrelevant in the New World Order. This clash of cultures, this Greek disgust for the freedoms of Egyptian women, is palpable in the administrative records of the time. The new rulers saw Egyptian customs not as a different, valid system, but as a sign of chaos and barbarism. Uncomfortable. Quote, from a fictionalized private letter from Apollonius, a Greek official in Alexandria, to his brother in Athens, circa 250 BCE. You would not believe the state of things in this country. The native women conduct themselves with a forwardness that would shame a prostitute in our city. They own businesses. They lend money. They stride into courtrooms and argue with men as if they were their equals. Their husbands seem to have no control over them whatsoever. It is a society turned upside down. The Ptolemy is wise to maintain our own laws for our own people. To live under their system would not be civilization, but a descent into madness. And here is the meta-commentary, the lesson in how a superior system can be defeated. It wasn't a frontal assault. It was death by 1,000 cuts. It was a slow, creeping infection. The Ptolemaic era introduced a fatal idea, that one's legal rights could be determined by one's ethnicity and gender. It created a world where an Egyptian woman could look at her new Greek neighbor and see that the law treated them differently, and that the Greek woman's legal chains were being presented as the new, civilized standard. The native legal tradition was not destroyed by a single decree. It was slowly poisoned by the prestige and power of the conquerors. The Greek contamination was the beginning of the end because it taught the world that you could have two sets of laws in the same land, and that the more oppressive one could be branded as the more advanced. The Greek infection was a slow-acting poison, weakening the immune system of Egyptian law over 3 centuries. But in 30 BCE, with the death of Cleopatra and the arrival of Octavian's legions, the patient was finally smothered. Rome did not come to Egypt to coexist. It came to dominate, to assimilate, to impose its own brutal and efficient operating system upon the world. And the core of that system, the legal principle that governed every aspect of Roman life from the Senate to the slave markets, was a concept of such absolute patriarchal authority that it made the Greek Kyrios look like a gentle suggestion. It was called patria potestas, the power of the father. And it was not a law. It was an iron cage of logic from which there was no escape. Patria potestas was the legal doctrine that vested the male head of a Roman family the paterfamilias, with complete and total authority over every single member of his extended household. This wasn't just guardianship, it was ownership. His power over his children, male and female, was absolute and lasted their entire lives, or until he chose to release them. In the early days of the Republic, this power extended to the right of life and death. While that was rarely exercised in later periods, the legal foundation remained. An adult son, even a victorious general or a respected senator, could not own property or sign a contract without his father's permission so long as the old man still lived. He was a legal extension of the paterfamilias. Now apply this logic to a woman. A Roman daughter lived under the absolute potestas of her father. She owned nothing. She controlled nothing. She was a piece of his property. When she married, one of two things happened. In an older form of marriage, she passed from her father's authority into the manus, literally, the hand, of her husband. Her legal existence was transferred from one owner to another. In a later, more common form, she technically remained under her father's potestas, even while living with her husband. In neither case did she ever, for a single moment, achieve the status of a legally independent adult. She was a ghost, a conduit through which property and lineage passed from one man to another. The concept of an Egyptian woman like Naunakta disinheriting her own children based on her own judgment would have been, to the Roman mind, a legal and moral abomination. It was a sign of a society that had completely lost its senses. When Rome formally annexed Egypt, this system became the law of the new masters. Roman law was the express lane to power, citizenship, and wealth. The old Egyptian courts were allowed to wither on the vine, handling petty local disputes, while any serious matter of property or commerce was increasingly funneled into the Roman legal machine. An Egyptian family seeking to curry favor, to secure a government contract, or to protect their land from confiscation had to Romanize. They had to adopt Roman legal customs, including the fiction of patria potestas. The economic and social pressure was immense. To survive, you had to become a little Roman, and that meant locking away your women, legally speaking. The Roman administrative mindset saw this imposition not as an act of oppression, but as a righteous and necessary act of bringing order to a decadent and chaotic culture. Classified memo from an official dispatch from the first Roman prefect of Egypt, Cornelius Gallus, to the Emperor Augustus, circa 29 BCE. Your Majesty, the pacification of this new province proceeds, but the challenges are not merely military. The native legal customs are a swamp of irrationality. We have found women here who believe they can inherit and dispose of land as they see fit, who enter into business contracts without male authority, and who dissolve their marriages on a whim. This breeds instability. It undermines the very foundation of the family, which is the bedrock of the state. I have issued an edict that all major property disputes and contracts shall henceforth be adjudicated according to Roman law. We will teach these people the meaning of order, and that order begins with the absolute and unquestionable authority of the paterfamilias. Civilization cannot be built on a foundation of female license. The meta-commentary is this: Patria potestas was the legal blueprint for the next 2,000 years of European patriarchy. It was more than just a law. It was a philosophy that re-engineered the family into a rigid, unbreakable hierarchy. It formally established the principle that a woman is not an individual before the law, but a subordinate component of a household owned and operated by a man. This doctrine, refined and adapted, would echo through the Justinian Code, through the canon law of the Church, and into the Napoleonic Code. The idea that a woman's legal identity must be subsumed by a man's, the very core of coverture, is the direct bastard child of Roman patria potestas. The Romans didn't just conquer Egypt with their legions, they conquered it with a legal idea so potent and so total in its subjugation that its shadow still falls upon us today. Legal frameworks are powerful, but they have a weakness. They are man-made. A law that is written can be unwritten. A system that is built can be dismantled. The Romans, for all their brutal efficiency, knew that force and bureaucracy alone could not guarantee a permanent order. To make a hierarchy last forever, you must convince both the master and the slave that it was not designed by men, but ordained by God. The legal regression that began with the Greeks and was perfected by the Romans needed a final, unshakable justification. It needed a soul, and it found one in the fertile volcanic soil of the Middle East with the rise of the great monotheistic religions. This was the masterstroke, the transformation of female subjugation from a political choice into a divine, unalterable command. The old Egyptian cosmos was a messy, chaotic, and wonderfully balanced place. It was populated by a sprawling family of gods and goddesses, each a cosmic force. There was Ra, the sun god, but there was also Nut, the sky goddess who birthed him each morning. There was Osiris, the lord of the underworld, but it was his wife, the goddess Isis, whose magical power and cunning brought him back to life. Isis was not a mere consort. She was a model of female agency, a powerful, intelligent, and fiercely independent deity who often outsmarted her male counterparts. A culture that worships a goddess like Isis has a built-in metaphysical space for powerful women. It makes a female pharaoh or a female landowner not just legally possible, but cosmologically conceivable. Monotheism changed the game entirely. It bulldozed the divine pantheon and replaced it with a single omnipotent and explicitly male god. The divine was no longer a balanced ecosystem. It was a pyramid scheme, with God the Father sitting alone at the apex. This was not just a theological shift, it was a political revolution. Human society, it was argued, must be a mirror of the divine order. If heaven was a patriarchal monarchy, then the family on earth must be one as well. The paterfamilias was no longer just a legal authority. He was God's appointed deputy, his rule over his wife and children a sacred reflection of God's rule over creation. And these new religions came with a foundational story, a creation myth that would be used as a legal precedent for the next 2,000 years. The story of Adam and Eve. This narrative, interpreted literally, became the ultimate weapon against female autonomy. First, Eve was created from Adam, a secondary being made from his rib to be his helper. This established a hierarchy from the first moment of her existence. Second, it was Eve who was deceived by the serpent who ate the forbidden fruit and who tempted Adam to do the same. This branded the female sex as inherently more gullible, morally weaker, and spiritually untrustworthy. She was the gateway through which sin entered the world. This wasn't just a story, it was an indictment, a divine justification for why women could not be trusted with property, power, or their own legal voice. To do so would be to invite the chaos of Eden all over again. The early architects of Christian theology seized upon this story and used it to hammer the final nails into the coffin of female freedom. Uncomfortable. Quote, from a fictionalized letter by an early church father to a congregation in Roman Alexandria, circa 250 CE. You write to me of the lingering pagan customs of women who still speak of their rights to property and divorce, as was their way before the light of Christ. You must teach them the truth of their own nature, as revealed in the Holy Scriptures. Was not the woman fashioned from the man? Was it not she who was deceived and became the transgressor? Her desire shall be for her husband, and he shall rule over her. This is not a Roman law, but God's law. Her subjugation is not a punishment, but a protection, a loving reign upon her weaker nature, for the salvation of her soul and the good order of the Christian family. Here is the final, devastating move. The meta-commentary is about the power of ideology to sanctify oppression. The legal chains of patria potestas were now holy relics. To question a husband's authority was no longer a civil dispute, it was blasphemy. A woman seeking a divorce was not just breaking a contract, she was defying God's plan for humanity. This ideological fusion was a form of psychological warfare. It convinced millions of women over centuries that their subordinate status was not only inevitable, but righteous. The cage was no longer a cage, it was a sanctuary, built by a loving God to protect them from themselves. Rebellion became unthinkable because the very thought was now a sin. The divine justification was the mortar, but the bricks of the new prison were forged in the chaos and violence that followed the collapse of the Roman world. As the empire crumbled, its grand, centralized legal machine ground to a halt. The world broke apart into 1,000 fractured pieces, a patchwork of warring fiefdoms ruled by a new class of strongmen, the landed warlords. In this brutal new landscape, there was no room for the complex abstractions of Roman jurisprudence or the cosmic balance of Ma'at. There was only one law, the law of the sword. And there was only one currency that mattered, land, and the loyalty of the men who fought for it. This was the dawn of feudalism, and it would mark the absolute bottom of the abyss for the legal status of women. It was the moment they ceased to be legal subordinates and became, in the bluntest possible terms, a form of high-value livestock. The feudal system was a pyramid of personal oaths, a desperate attempt to impose order on a world gone mad. A king granted land, a fief, to a powerful lord. In exchange, that lord became the king's vassal, swearing an oath of fealty and promising to provide knights for the king's army. That lord, in turn, would grant smaller parcels of his land to lesser knights, who would swear their own oaths to him. It was a chain of male loyalty, sealed by the promise of military service and cemented by the control of agricultural land. Now ask the essential question, where does a woman fit into this structure? The answer is nowhere. A woman could not swing a sword. She could not lead an army into battle. She could not swear a binding oath of fealty, as her loyalty was already owed to her husband or father. In the brutal calculus of feudalism, she was a non-entity. She had no place in the chain of power because she could not fulfill the primary duty upon which the entire system was built, but this did not make her useless. On the contrary, it gave her a new and horrifying purpose. She became the currency of diplomacy. She was the walking, breathing treaty, the living seal on an alliance. In a world of constant, low-grade warfare, the only way for a lord to secure his borders and a blood feud, or acquire a strategic castle, was not through conquest alone, but through marriage. The entire political landscape of medieval Europe was drawn and redrawn through the strategic marriages of daughters. A daughter was not a person to be educated or a soul to be nurtured. She was the most valuable bargaining chip her father possessed. Her marriage was not a personal choice, it was a move on a geopolitical chessboard, planned from the moment of her birth. Her value lay entirely in the lands and armies her hand could deliver to her future husband, and by extension, to her father's political ambitions. The personal desires, the intellect, the very humanity of the woman in question were not just secondary. They were completely and utterly irrelevant. She was an object, a piece of property being transferred from one male owner to another, and the terms of that transfer were the only thing that mattered. Remember the Egyptian marriage contract, negotiated to protect the woman's own financial future? That world was dead. A medieval marriage contract was a negotiation between two men, the bride's father and the groom, about the transfer of property. The dowry was not the bride's to control. It was a payment to the groom's family. The woman herself was the centerpiece of the transaction, and she had no more say in the matter than a prize-winning heifer at a country fair. This cold, transactional view of women as political tools is not a cynical modern interpretation. It is stated with blunt, unembarrassed clarity in the chronicles and private correspondence of the men who ran this world. Uncomfortable. Quote, from a fictionalized letter from an aging Norman baron to his ambitious son, circa 1100 CE. You ask why you must marry the daughter of Lord de Montfort. She is plain and I am told sullen. Your question is that of a boy. You do not marry the girl, you marry her father's lands. You marry the 50 lances he will bring to our banner. You marry the castle that guards the northern pass. Her womb will provide you with an heir to hold those lands, and her presence in your bed will keep her father's sword from our throats. That is her purpose. Find your pleasure elsewhere if you must, but you will make this match, for the survival of our house depends on it, not on your romantic fancies. The meta-commentary is this. The feudal system perfected the commodification of women. By creating a power structure in which they had no natural place, it stripped them of all intrinsic value and redefined them by their extrinsic, transactional use to men. This mindset, born in the drafty castles of the aristocracy, inevitably filtered down through the rest of society. If a noble lady was a pawn in the games of men, then a peasant girl was infinitely more expendable. This was the great legal regression in its final, most brutal form. It was not just the loss of rights, it was the loss of personhood itself. The woman was no longer a legal actor, but a piece of legal property, and the world had been remade to reflect that terrible, simple fact. If feudalism turned a woman into a commodity, a new legal doctrine would soon emerge to provide the intellectual and procedural framework for that commodification. It was a concept so elegant in its totality, so chilling in its efficiency, that it stands as perhaps the single most successful act of legal erasure in human history. It was born in the common law of England, but its principles would infect the legal systems of Europe and the Americas for the next 700 years. It was called coverture, and it was nothing less than the complete and total annihilation of a married woman as a person in the eyes of the law. It took the Roman idea of patria potestas and the feudal concept of woman as property, and it fused them into a single, seamless, and inescapable legal reality. The doctrine of coverture was built on a simple, almost poetic legal fiction. Upon marriage, the husband and wife ceased to be two separate individuals and became a single entity. But this was not a union of equals. As the great English jurist William Blackstone would later explain, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband. Think about that language. Suspended, incorporated. It was a hostile takeover of a human soul, conducted in a church, sanctioned by the state. Before her wedding, a woman was a feme soul, a single woman who had at least some limited legal rights, though nowhere near what her Egyptian ancestors had. The moment she said "I do," she became a feme covert, a covered woman. Covered, that is, by the legal identity of her husband. She became a shadow, a legal ghost tethered to a man. Under this doctrine, the obliteration of her rights was absolute. First, her property. Any land, money, or goods she owned before the marriage now fell under her husband's exclusive control and management. He could collect the rents, spend the money, sell the goods. It was his. Second, her earnings. Any wages she might earn belonged by law to her husband. Her labor was his property. Third, her right to contract. As a legal non-entity, she could not sign a contract. She could not incur debt. She could not run a business. Fourth, her right to a legal voice. She could not sue someone who had wronged her. She could not be sued for her own actions. If she was the victim of an assault, it was her husband who had to bring the lawsuit, because she was legally his property, and it was his property that had been damaged. This was not a series of unfortunate, disconnected laws. It was a total system, a hermetically sealed cage from which there was no exit. The Egyptian woman who could sue her neighbor, run her own business, and write her own will was not just a distant memory. She was now a legal impossibility, a creature from a fantasy world. Coverture was the operating system of patriarchy, and its foundational code was stated with a calm, paternalistic condescension by the very men who enforced it. Uncomfortable. Quote, from William Blackstone's Commentaries on the Laws of England, 1765, the single most important legal text in the English-speaking world for centuries. By marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended. Upon this principle, of a union of person and husband and wife, depend almost all the legal rights, duties, and disabilities that either of them acquire by the marriage. Even the disabilities which the wife lies under are for the most part intended for her protection and benefit. So great a favorite is the female sex of the laws of England. There it is, the ultimate gaslighting. The legal death of a woman is reframed as an act of kindness. Her chains are for her own protection and benefit. The law that renders her a helpless dependent is proof that she is a great favorite. This is the language of the benevolent tyrant, the logic of the gilded cage. The meta-commentary is that coverture became the bedrock of legal inequality for centuries. It was not some dusty, forgotten medieval relic. It was the law in England and the United States well into the 19th and even early 20th centuries. The entire first wave of the women's rights movement was not about radical new ideas. It was a desperate, bloody, inch-by-inch battle to dismantle the cage of coverture. They were fighting simply to regain the status of legal person, a status their ancestors in ancient Egypt had taken for granted 3,000 years before. Coverture was the perfection of the Great Regression, the final legal coding that made a woman's subjugation seem not just normal, but natural, and even kind. Picture a courtroom. Not the clean, well-lit rooms of our modern world, but a dark, damp stone chamber in medieval Europe. The air is thick with the smell of unwashed bodies and the smoke of tallow candles. A judge, wrapped in fur, presides. A man, the plaintiff, is making his case with righteous fury. Another man, the defendant, is denying it. Lawyers, clerks, guards, all men. Now, look closer. In the corner, there is a woman. She is the reason they are all here. The crime was committed against her. Her property was stolen, her body was bruised, her reputation was slandered, and she is completely, utterly silent. This is not by choice, it is by law. She is muzzled, a ghost at her own trial, her voice legally ripped from her throat. This silent, powerless figure is the end result of the Great Regression, the final product of a system that had successfully convinced itself that justice could be achieved by listening to only half of the story. Remember Haria, the Egyptian woman from Deir el-Medina, who stood before the judges and declared, "I speak with my own mouth. I require no man to speak for me." Her world is now so distant it might as well be on another planet. The medieval woman standing in that stone chamber is legally barred from imitating her. Under the doctrine of coverture, she is not a legal person. She cannot initiate a lawsuit. If she has been wronged, the lawsuit must be brought by her legal owner, her husband. It is his name on the court docket, because it was his property that was damaged. The court does not see a woman who was assaulted. It sees a husband whose domestic servant has been temporarily rendered less useful. She is the subject of the dispute, but not a participant in it. She has no more right to speak than a farmer's stolen ox would have. Even if her voice is permitted in the role of a witness, it is a voice that the law has predetermined to be untrustworthy. Building on the theological foundation of Eve's deceitfulness, medieval legal codes were rife with explicit devaluations of female testimony. In some Germanic traditions, the oath of a woman was worth half that of a man. In others, the testimony of 2 or even 3 women was required to equal that of a single male witness. Her perspective was institutionally suspect. Her memory was deemed faulty, her emotions too volatile, her very nature prone to fabrication and hysteria. She was a flawed instrument, and any information she provided had to be treated with extreme caution. The Egyptian court, in its pragmatic quest for mayat, sought truth from every available source. The medieval court, in its quest to uphold a patriarchal hierarchy, decided in advance that truth could only come from a male mouth. This institutionalized distrust created a legal landscape of unimaginable horror for women. How can a woman seek justice for rape when the law assumes from the outset that she is probably lying? How can she defend her inheritance when her testimony against a male claimant is automatically given less weight? The answer is, she can't. The system was a perfect self-insulating machine for male impunity. Uncomfortable. Quote, from the fictionalized private writings of a 13th century English judge, the plea was brought by Baron Fitzwilliam concerning an attack upon his wife. The woman was brought forth to give her account, and she wept and raged as is their custom. One must always filter such testimony through the lens of reason. The female mind is a vessel for passion, not logic. It is swayed by the moon, by vapors, by imagined slights. It is for this reason the law wisely places her under the steady hand of her husband, who can bring the matter to the court in a sober and truthful manner. To allow such creatures to plead for themselves would be to turn the courtroom into a theater, and justice would be drowned in a flood of tears. The meta-commentary is that this legal principle, the inherent unreliability of women, is the most tenacious ghost of this entire regression. It haunts us still. It is the ancestor of every cross-examination that focuses on a victim's sexual history. It is the root of the question, what were you wearing? It is the foundation of the cultural reflex to dismiss women's accounts of pain, abuse, and harassment as exaggeration or emotional instability. The muzzling of the medieval woman in the courtroom was not just a legal procedure. It was a lesson taught to the world over and over for 1,000 years. Her story doesn't count. The silencing of a woman's voice in the courtroom was the logical consequence of a much deeper theft. You cannot allow someone to speak for themselves when you have already stolen everything they own. It is an inconvenient risk. The medieval legal system, having declared a woman a non-person, had to complete the illusion by ensuring she was also a pauper. The vast economic power wielded by the women of Egypt, the power to own, to inherit, to control, and to bequeath, was not just taken away. It was replaced by a sophisticated new legal architecture designed specifically to ensure that wealth would forever flow around women, but never through them. They were no longer reservoirs of capital. They were conduits, temporary pipes through which property passed from one generation of men to the next. The first great engine of this dispossession was the law of primogeniture. It was a simple, brutal, and devastatingly effective rule. When a landowner died, his entire estate, the land, the title, the castle, everything that mattered, passed intact to his eldest son. Daughters were excluded. Younger sons might get a small provision, but the core of the family's power was kept consolidated in a single male line. This was a radical departure from the Egyptian system, where property was often divided among all children, male and female. Primogeniture wasn't just about inheritance. It was about dynastic survival in a violent, unstable world. It prevented the great feudal estates from being broken up into smaller, weaker parcels. And in this system, a daughter who inherited land was not just an inconvenience. She was a threat, a potential drain through which the family's power could leak away into the hands of another man through marriage. So the law simply wrote her out of the equation. But what about widows? A system that cast millions of widowed women into abject poverty would be unstable. So the law created a clever and deeply cynical solution: the dower right. On the surface, it looked like a protection. A widow was legally entitled to a life interest in 1/3 of her late husband's lands. It was her pension, her means of survival. But the key phrase is life interest. She was a tenant, not an owner. She could live on the land and collect its revenues until her death, but she could not sell it. She could not mortgage it. And most critically, she could not will it to anyone. She had no say in its ultimate fate. The moment she died, her dower lands automatically reverted to her husband's male heir, her son, or his brother, or his nephew. She was a steward, a temporary caretaker, a vessel that held a fragment of a man's wealth for a few short years until the next man in line was ready to claim it. Compare this to the Egyptian widow who inherited property outright and could do with it as she pleased. Remember the Lady Nonakte, who used her absolute power of ownership to reward the children who cared for her, and mercilessly disinherit those who didn't? That level of agency was now gone. The medieval widow had no such power. She was a placeholder, a legal ghost haunting 1/3 of her husband's estate, waiting for death to complete the transfer of property back into the male bloodstream of the family. The legal justifications for this system were, as always, framed in the language of protection and good order, a paternalistic logic that barely concealed its true dynastic purpose. Uncomfortable. Quote, from a fictionalized ruling by a judge in the Court of Common Pleas, England, circa 1400, the widow's dower is a sacred provision of the common law designed to ensure she is not cast out. But her right is one of use, not of title. The land is the patrimony of the House of Greystoke, passed from father to son since the conquest. It is not hers to alienate. She is but a guardian of it for her lifetime, a vessel to hold it in trust for the rightful male heir upon her passing. To grant her the power of sale or testament would be to risk the dismemberment of the estate, which would be an offense against the stability of the realm and the memory of her husband. The meta-commentary is about the creation of permanent, structural poverty for women. This system ensured that women could never accumulate generational wealth. A man could build a fortune and pass it to his son, who would add to it and pass it to his son. A woman could not. Any wealth she possessed was either a temporary dowry that passed to her husband's control, or a temporary life estate that would revert to his family. She was locked out of the great game of building dynasties. This economic castration, more than any other factor, cemented female dependence as the unshakable norm for centuries. It created a world where a woman's only path to security was through a man, and her greatest fear was losing him. The legal and economic architecture of the medieval world had successfully built a cage for women, bar by iron bar. The feudal system defined her as a commodity. The laws of primogeniture and dower dispossessed her. The doctrine of coverture performed her legal execution. But a physical cage, no matter how strong, is still just a cage. A prisoner, however powerless, still knows she is a prisoner. She can still dream of the world outside, of a life she once had or could have. The final and most diabolical step in this great regression was to convince the prisoner that the cage was not a prison at all, but a holy sanctuary. It was to lock the door, melt the key, and declare that the very desire for freedom was a mortal sin. This was the work of the church, and its chosen instrument was the re-engineering of marriage from a human contract into an unbreakable divine sacrament. Remember the Egyptian marriage agreement? It was a secular document, a business deal. Its power came from its pragmatism. It had clauses, conditions, and above all, an exit strategy. It was a contract designed for the real world, a world of mistakes, of changing hearts, of failed partnerships. The Catholic Church looked upon this practical, worldly arrangement with horror. It saw not a tool for justice, but a gateway to chaos. A society where women could simply walk away from their husbands was a society without order, a world built on the shifting sands of human whim. To build a permanent Christian civilization, they needed a permanent foundational unit, the indissoluble family. And to get that, they had to take marriage out of the hands of lawyers and give it to God. The transformation was a masterpiece of ideological warfare. Marriage was no longer a civil union you entered into. It was a sacrament you received. It was not a promise between two people. It was a vow made before God Himself. And a vow made to God cannot be broken by mere mortals. With this single theological shift, the Church stripped away all the contractual escape clauses that Egyptian women had taken for granted. The right to initiate a divorce was gone. The no-fault, walk-away freedom was gone. The very concept of an endpoint was declared a heresy. An unhappy marriage was no longer a failed agreement to be dissolved. It was a cross to be carried, a test of faith, a form of holy suffering that would purify the soul. Of course, the powerful always need a back door. While divorce was made impossible for the common person, the Church created a cynical loophole for the rich and well-connected: the annulment. An annulment was not a divorce. It was a legal declaration, after years of expensive litigation and generous donations to the Church, that a valid marriage had never existed in the first place due to some technicality. The couple were too closely related by blood. One party had not given free consent. The marriage was not consummated. It was a theological get-out-of-jail-free card for the aristocracy, while the peasant woman remained chained to her drunken, abusive husband for life, told that her suffering was God's will. This was not a system designed for justice. It was a system designed for absolute control. It locked down the transfer of property, it ensured clear lines of inheritance for the feudal lords, and it cemented the husband as the undisputed, divinely appointed monarch of his home. Uncomfortable. Quote, from a fictionalized letter by a powerful archbishop to a bishop in a newly converted territory, circa 900 CE. You write of the people, his reluctance to abandon their old custom of hand-fasting and easy separation. You must be firm. The stability of Christendom is not built on the fleeting passions of men and women, but on the bedrock of the permanent family. By making marriage an unbreakable sacrament, we do more than save souls. We bind the land to the family, and the family to the Church. It ends the chaos of disputed heirs and wandering women. It makes the husband the priest of his own home, and us the arbiters of all homes. Teach them that a marriage vow is like their vow of baptism, eternal. Their earthly suffering within it is a small price to pay for the order it brings to the world and the salvation it brings to their souls. The meta-commentary is this: the sacralization of marriage was the final turn of the key. It took the legal and economic chains and sanctified them. A woman's desire to leave an abusive or miserable situation was no longer a simple assertion of personal will. It was now a spiritual crime, a rebellion against God. This removed her last shred of leverage. In the old Egyptian system, a husband knew that if he pushed his wife too far, she could leave, taking her property and a hefty financial penalty with her. That threat created a balance of power. The medieval husband had no such fear. His wife was trapped. Her only recourse was prayer. Her only hope was the afterlife. This system didn't create holy families. It created millions of tiny, unassailable tyrannies, each ruled by a man whose power was now absolute, backed not by the law of the state, but by the law of the Almighty. The cage was now complete, its bars forged from law, its lock sanctified by God. For the vast majority of women, the lesson was clear: submit, obey, and disappear into the legal shadow of a man. But what of those who could not, or would not? What of the woman whose husband died, leaving her a widow with a small piece of property? What of the woman who possessed a skill, in healing, in midwifery, in brewing, that allowed her a measure of economic independence? What of the woman who simply chose not to marry? These women were the system's glitches, anomalies that could not be accounted for by the neat patriarchal flowchart. They were women living, however tenuously, outside of direct male control. And for these women, the system had a final, terrifying solution. When control failed, there was always fire. The witch hunts that swept across Europe were not just a spasm of religious hysteria. They were a targeted, systematic campaign to eliminate the last remaining pockets of female autonomy. It was a purge, and its primary targets were economically independent women. The official story, the one we are told, is one of superstition, of ignorant peasants and fanatical priests, whipped into a frenzy by a fear of the devil. And of course, that was part of it. But it is a dangerously incomplete picture. To focus only on the religious hysteria is to miss the cold, hard economic and social calculus that lay beneath it. The witch hunts were a weapon, and like any weapon, they were aimed with a purpose. Look at the profiles of the accused, and a pattern emerges with terrifying clarity. They were rarely the wives of powerful men. More often than not, they were the outliers. First, there was the widow. Under the dower right, she controlled a portion of her late husband's property. She was the head of her own household. She was not under the thumb of a father or a husband. This made her an anomaly and an inconvenience. Her control of the land stood in the way of the male heir who wanted it. Her independent status was a quiet rebuke to the idea that a woman needed a man to survive. An accusation of witchcraft was the perfect tool. It not only eliminated her, but it often meant her property was forfeit, conveniently absorbed by the local lord or the very men who accused her. Second, there was the healer, the midwife, the herbalist, the cunning woman. For centuries, these women had been the primary healthcare providers in their communities. They possessed a body of knowledge passed down through generations about childbirth, remedies, and the cycles of the female body. This was a form of power. It was an expertise that existed outside the two great male hierarchies, the church and the emerging universities that were beginning to train male physicians. The church saw these women as spiritual rivals, their folk remedies as pagan superstitions that bordered on sorcery. The new male doctors saw them as economic competition. By branding the female healer a witch, the establishment could discredit her knowledge, terrify her patients, and consolidate its own monopoly on the lucrative business of medicine. A successful birth was a miracle of God guided by a male physician. A successful birth guided by a midwife was evidence of a pact with the devil. Finally, there was any woman who was simply difficult. The unmarried spinster who owned her own small cottage. The sharp-tongued woman who argued with her neighbors. The woman who was too successful in the marketplace. In a world that demanded female submission, a woman's success or independence was in itself suspicious. How could she achieve it without a man's guidance? The easiest answer was, she couldn't, not by legitimate means. Her unnaturally fine butter, her strangely healthy livestock, her ability to thrive alone, these were not signs of skill, but signs of a dark pact, uncomfortable. Quote, from the infamous witch-hunting manual, the Malleus Maleficarum, 1487, a real text that was treated as an infallible guide by inquisitors for centuries. When a woman thinks alone, she thinks evil. They are more credulous, and since the chief aim of the devil is to corrupt faith, he rather attacks them. And blessed be the highest who has so far preserved the male sex from so great a crime, for he was willing to be born and to suffer for us in that sex. The manual goes on to detail how a woman's knowledge of secret things, like healing, is a primary indicator of witchcraft. The meta-commentary is that the witch hunts were an act of mass-scale psychological terrorism. The goal was not just to eliminate a few thousand nonconformist women, it was to teach every woman a lesson. The message, burned into the collective female consciousness, was simple. Do not be independent. Do not be powerful. Do not be knowledgeable. Do not be old and alone. To be safe, you must be married, you must be submissive, you must be poor, and you must be silent. Ambition in a woman was not just a sin, it was a death sentence. This created a culture of fear that would police women's behavior for centuries, long after the fires had gone out. The fire was for the outliers. It was the brutal, spectacular cauterizing of a wound, a warning to any woman who dared to step too far out of line. But terror, as a tool of social engineering, has its limits. It is inefficient. It is messy. A far more effective method of control is not the public execution, but the quiet, bureaucratic memo. The slow, patient rewriting of the rules until the behavior you want to eliminate is not just dangerous, but impossible. While the witch hunts terrorize the independent woman into submission, a far more mundane and systematic assault was being waged in the workshops and marketplaces. This was the war of the guilds, and its goal was the final, non-violent, and total economic strangulation of women. Remember the world of the Egyptian woman? The world of brewers, weavers, landlords, and merchants who signed their own contracts and managed their own businesses? That world wasn't just burned at the stake. It was slowly starved to death by 1,000 tiny legalistic cuts. The instrument of this starvation was the guild, the professional association that was the backbone of the medieval urban economy. On the surface, a guild was a respectable institution, a brotherhood of master craftsmen, bakers, weavers, chandlers, goldsmiths, dedicated to upholding the standards of their trade, regulating prices, and providing a social safety net for their members. But the key word was always brotherhood. From its very inception, the guild was an explicitly male institution, a fraternity whose primary, unstated function was to create and protect a male monopoly on skilled, profitable labor. The exclusion was systematic and brutally effective. The only path to becoming a master craftsman was through a long apprenticeship. And one by one, the guilds rewrote their charters to explicitly forbid masters from taking on female apprentices. No apprenticeship, no mastery. No mastery, no legal right to practice the trade. The door was slammed shut and bolted from the inside. Even in trades where women had traditionally been dominant, such as brewing, the alewives, and textile production, the process of guild formation was a story of hostile takeover. Men would organize a brewers' guild, then use their collective political power to lobby for regulations that drove independent alewives out of business, rules about the scale of production, the times of sale, the types of ingredients, all designed to favor the large, male-owned operations. The pattern was the same everywhere. The skilled, independent female artisan of the ancient world was replaced by the marginalized, low-wage female worker of the medieval one. Women were pushed out of the profitable, organized trades and into the ghetto of women's work, spinning thread for male weavers, washing wool, sewing seams for male tailors. They were relegated to the low-skilled, repetitive piecework that fed the male-owned guilds. Their labor essential, but their status permanently degraded. They were no longer entrepreneurs. They were the first proletariat, a vast pool of cheap, disenfranchised labor with no guild to protect them and no legal path to advancement. The one exception only served to prove the rule. In some guilds, a master's widow was permitted to carry on her husband's business after his death. This looks like a concession, a moment of compassion. It was not. It was a temporary license, not a right. She could finish his outstanding contracts, but she was almost always forbidden from taking on a new apprentice. This was the critical restriction. It ensured that the business and the knowledge it contained would die with her. She was a placeholder, a human bridge ensuring the workshop didn't go dark before it could be passed on to another man. The charters of these guilds, written in the dry, self-important language of medieval bureaucracy, reveal the quiet violence of this exclusion. They never say, "We hate women." They say, "For the good order of the craft." Classified memo from the fictionalized charter of the Worshipful Company of Coopers, Barrel Makers, London, circa 1350. It is ordained by the masters and goodmen of this fellowship, for the protection of our trade and the assurance of quality, that no member shall take as apprentice any person save a freeborn boy of good character. The work of shaping the stave and binding the iron is a heavy labor, unsuited to the weaker frame of a woman. Furthermore, the workshop is a place of brotherhood and sober industry, the presence of which would be a distraction to the apprentices and a disruption to the harmony of the craft. Let the women tend to the hearth, and let the men tend to the barrel, as God and nature have intended. The meta-commentary is about the deliberate construction of the male world of work. The idea that business, finance, and skilled trades are inherently masculine domains is a lie. They became that way because they were made that way, through a centuries-long campaign of legal and economic exclusion. This lockout then created the very reality it claimed to be based on. By preventing women from practicing skilled trades for generations, the system created a world where women were, in fact, unskilled. Their resulting poverty and dependence were then held up as proof of their natural inferiority, their inability to handle the rigors of the real world. It was a perfect circular argument, a self-fulfilling prophecy written in guild charters and enforced in every workshop in Christendom. A system of total subjugation cannot survive on laws and economics alone. Brute force can build a prison, but it cannot make the prisoners believe it is their natural home. To achieve that, you need a story, an intellectual architecture so vast and so seemingly rational that it becomes synonymous with truth itself. You need the smartest men in the world to stand up, one after another for 1,000 years, and declare with the full weight of their authority that the cage is not a cage, but a perfect expression of the natural order. The final lock on the medieval world was not forged by kings or priests, but by philosophers. The great thinkers of Western civilization, the very men we celebrate as the fathers of logic and reason, were the ones who drew the blueprints for the intellectual prison of women, arguing with calm, devastating certainty that female inferiority was not a social construct, but a scientific and metaphysical fact. The fountainhead of this intellectual poison was, ironically, one of the greatest minds in human history, Aristotle. His influence on Western thought is impossible to overstate. For 2,000 years, his writings were not treated as theories, but as settled science, and Aristotle's science was unequivocal. In his biological works, he argued that the male is the active principle in reproduction. The male provides the form, the soul, the spark of life. The female is merely the passive principle, providing the inert matter, the raw material, the empty vessel. From this scientific observation, he drew a staggering conclusion. A female is essentially an incomplete or misbegotten male, a deformity, a natural but deficient version of the perfect human form, which was, of course, male. This biological fact was the foundation for his political philosophy. In his treatise, Politics, he laid out the proper order of the household, which was the microcosm of the state. The soul, he argued, must rule the body. Reason must rule passion, and therefore, the male who possesses superior reason must naturally rule the female, who is deficient in it. This was not tyranny in his view. It was nature. A household where a woman held power was as disordered and unnatural as a body where the feet tried to command the head. This Aristotelian model was the gift that kept on giving for every patriarchal thinker who followed. When the Roman Empire adopted Christianity, the early church fathers like Tertullian and Augustine took Aristotle's rational science and gleefully fused it with the theology of Eve's original sin. The result was a devastatingly effective hybrid argument. A woman was not just morally weaker because of Eve's transgression. She was biologically, scientifically, and rationally inferior, as proven by the greatest philosopher who ever lived. It was a 1-2 punch from which there was no recovery. Faith and reason, for once, were in perfect, harmonious agreement. The final seal was placed on this intellectual edifice in the 13th century by St. Thomas Aquinas. His work was the grand synthesis of Christian theology and Aristotelian philosophy, and it would become the official philosophical bedrock of the Catholic Church for centuries. Aquinas took Aristotle's misbegotten male theory and Christianized it, smoothing out its harsher edges to fit a benevolent God. A woman wasn't a mistake of nature, he argued, but a creature intentionally designed by God to be subordinate. She was created specifically for one purpose: procreation. For all other tasks, he famously argued, a man would be better helped by another man. Her inferiority, her lack of rational authority, was a feature, not a bug. It was a beautiful and necessary part of God's diverse and hierarchical creation. Uncomfortable. Quote, from a fictionalized scholastic disputation at the University of Paris, circa 1270, the question is raised, is the woman the equal of the man? We must answer in the negative. As the philosopher Aristotle has demonstrated, the active virtue is in the male, the passive in the female. As Holy Scripture teaches, the woman was made from the man, and for the man. Her reason is sufficient for the governance of the household under the authority of her husband, but it does not extend to the governance of a city or a kingdom. This is not an injustice, but a reflection of the divine order. For as the moon takes its light from the sun, so the woman takes her guidance from the man, and in this perfect hierarchical harmony, the will of God is made manifest. The meta-commentary is this. This was the ultimate act of intellectual violence. It took prejudice and dressed it up in the robes of logic. It made misogyny look like metaphysics. For centuries, any woman who dared to demand her rights was not just fighting her husband or her king. She was fighting Aristotle. She was fighting the Church Fathers. She was fighting Thomas Aquinas. She was fighting reason itself. This philosophical architecture was perhaps more effective than any law because it aimed to colonize the minds of women themselves. It sought to convince them that their subordinate position was natural, logical, and just. It was the final step in making the prison invisible, by convincing the prisoner she was born to be there. The intellectual case was now closed. The greatest minds of the New World, from the philosophers of Athens to the saints of the Church, had all reached the same seemingly unshakable conclusion. The woman was an inferior being designed by nature and by God for a life of submission. The argument was airtight, a fortress of logic and faith, but it had one catastrophic vulnerability, a single inconvenient and deeply buried body of evidence that proved the entire edifice was built on a lie. What do you do when your grand theory of natural order is directly contradicted by 3,000 years of history? You don't change the theory, you bury the history. The final act of the Great Regression was not an act of creation, but one of destruction. It was a slow, deliberate, and chillingly successful campaign of induced amnesia, a war waged not on people, but on memory itself. The legal freedoms of the ancient Egyptian woman were not just lost to the gentle decay of time, they were actively murdered. The murder weapon was not the sword, but the selective silence of the men who became the gatekeepers of history. The process began in the quiet, candle-lit scriptoriums of medieval monasteries. The monks who toiled there were not historians in our sense of the word. They were custodians of a very specific tradition, the Judeo-Christian, Greco-Roman one. Their sacred duty was to copy and preserve the texts that mattered: the Bible, the writings of the Church Fathers, the laws of Rome, the philosophy of Aristotle. This was the canon. This was the story of how the world came to be, as they understood it. Now imagine a monk in the 10th century coming across a fragment of a Ptolemaic-era papyrus, a translation of an old Egyptian marriage contract. What would he see? He would not see a sophisticated legal document. He would see the bizarre, incomprehensible ramblings of a pagan culture. He would read of women owning property, initiating divorce, and suing men. In his world, a world governed by coverture and canon law, this was not just illegal, it was satanic. It was a vision of a world turned upside down, a world in rebellion against God's law. Would he waste precious, expensive parchment and months of his life copying such a text? Of course not. He would set it aside, perhaps use it for scrap, and return to his important work of copying another sermon by St. Augustine. This was not necessarily an act of malicious censorship. It was an act of triage, of value judgment. And the result, repeated thousands of times across Europe, was that the legal and social history of Egypt was left to turn to dust, while the intellectual architecture of patriarchy was copied, recopied, and preserved for eternity. When physical evidence was too large to ignore, a monument like Hatshepsut's temple, for example, the second technique was employed: pathological misinterpretation. Historians, from the classical era to the 19th century, looked at the evidence of a female pharaoh and did not allow it to challenge their core assumptions. Instead, they used their assumptions to pathologize her. She was a virago, a cross-dressing usurper, a sexually deviant woman who unnaturally craved the power of a man. Her success was not evidence that a woman could rule effectively. It was evidence of her personal moral corruption. The historical fact was contained, quarantined, and explained away as a freakish aberration, ensuring that the grand narrative of male rule remained undisturbed. This quiet, relentless campaign of neglect and misinterpretation was not a conspiracy in the sense of a secret meeting in a smoke-filled room. It was a conspiracy of consensus, an unspoken agreement among the educated men who wrote the history books that some truths were more valuable than others. Uncomfortable. Quote, from a fictionalized entry in the commonplace book of a Renaissance humanist scholar, circa 1550. I have read the accounts of Herodotus and others concerning the strange customs of the Egyptians, particularly the license they afforded to their women in matters of property and marriage. One must treat such tales with caution. They are the chronicles of a heathen people, unguided by the light of Christ or the reason of the Greeks. To dwell on such unnatural arrangements is to risk unsettling the minds of the simple. History is a moral art. Its purpose is to instruct men in virtue and good governance, not to catalog the errors of the past. The proper and natural station of women has been settled by both God and reason. Let us not muddy the waters by giving undue attention to the curiosities of a fallen world. The meta-commentary is the most devastating part of this story. The result of this amnesia was that for over 1,000 years, the world forgot that any other way of life had ever existed. It created a historical timeline that began in a patriarchal Eden, moved through the patriarchal worlds of Greece and Rome, and culminated in the perfectly patriarchal world of Christendom. It made patriarchy look like the default human condition. This meant that when the first stirrings of the women's rights movement began in the 18th and 19th centuries, they were fighting in a historical vacuum. They were not seen as trying to reclaim rights that had been stolen. They were seen as dangerous radicals demanding unnatural rights that had never existed. They had been robbed of their own history, of their own precedent. They were fighting without the powerful knowledge that the world had not in fact always been this way. They were trying to invent a future, completely unaware that they were actually fighting to recover a distant, murdered past. History is not without its moments of cruel, breathtaking irony, and perhaps the cruelest of all is the story of the French Revolution. It was supposed to be the Great Dawn, the moment humanity threw off the chains of superstition and feudalism and stepped into the clean, rational light of reason. It was the age of the Declaration of the Rights of Man and of the Citizen, a document that boldly proclaimed that men are born and remain free and equal in rights. But in the smoke and chaos of the revolution, a new strongman emerged, a man who promised to bring order to the world: Napoleon Bonaparte. He was a military genius, a political visionary, and the architect of the modern state. He was also the man who would take the scattered, archaic principles of female subjugation and forge them into a new, modern, and terrifyingly efficient legal cage, the Napoleonic Code. The Civil Code of 1804, later known as the Napoleonic Code, was Napoleon's crowning achievement. It was a masterpiece of legal rationalization, designed to replace the tangled mess of feudal and royal laws with a single unified system for all of France. It was hailed as the ultimate expression of revolutionary logic. It was also, for the women of France and soon the world, a declaration of total war. The code did not just ignore women's rights, it went out of its way to systematically and explicitly destroy them, taking the half-erased ghost of coverture and resurrecting it with the full power of the modern, centralized state. The revolution had briefly, chaotically offered women a glimpse of freedom, the right to divorce by mutual consent, some inheritance rights. Napoleon saw this as a symptom of social decay, and his code was the cure. Under the Napoleonic Code, the married woman ceased to exist. Article 213 stated it with chilling simplicity. A husband owes protection to his wife, a wife obedience to her husband. This was not just a moral suggestion, it was the law of the land. A woman could not sell property, buy property, receive a gift or work a job without the written consent of her husband. He was the legal master of all their shared property. He was her legal guardian. She was, once again, a legal minor, a perpetual child. Divorce was made nearly impossible for a woman. A husband could divorce his wife for a single act of adultery. A wife, however, could only divorce her husband if he was foolish enough to move his mistress into their shared family home. The double standard was not a bug. It was a core feature, written in the cold, clear language of the law. This was not a reluctant compromise or a holdover from the old days. This was a deliberate, consciously designed system, born from Napoleon's own deeply held misogynistic beliefs. He saw the independent woman as a threat to the two things he valued most: social order and military strength. A stable state, in his view, was built on stable families, and stable families were built on the absolute, unquestionable authority of the husband. Uncomfortable. Quote, from a fictionalized note dictated by Napoleon to the jurists drafting the Civil Code circa 1802. The jurists are debating the rights of the wife. They are fools. Nature herself has made our women our dependents. They are flighty, emotional, and concerned with trifles. They need the firm hand of a man to guide them, just as a ship needs a captain. The family is a small kingdom, and the husband must be its king. The law should not concern itself with the romantic fantasies of women. It should concern itself with the stability of France. A woman who can act without her husband's consent is a loose cannon on the deck of the state. Give the husband the authority. It is simpler, it is more natural, it is better for France. The meta-commentary is about the devastating global impact of this single document. Napoleon's code was not just for France. As his armies swept across Europe, they brought the code with them. It was imposed on Italy, the Netherlands, Belgium, and parts of Germany and Poland. It became the legal foundation for the new nations of Latin America that broke away from Spain. It even influenced the laws of Quebec, Louisiana, and parts of the Middle East. This was the mechanism that took medieval patriarchy, gave it a fresh coat of revolutionary paint, and exported it across the globe as the very model of a modern legal system. At the very moment when the world was looking for a new way forward, Napoleon handed them a map that led directly back into the past. It was the Great Regression, repackaged for a new century. We have followed the long, dark road of the Great Regression, from the sunlit courts of Thebes to the suffocating confines of the Napoleonic Code. We have witnessed the systematic dismantling of a world, the murder of an idea. But this is not just an academic exercise in comparing ancient laws. These two systems, these two radically different ways of organizing human society, were not just legal theories. They were civilizational experiments, run in parallel over thousands of years. And the results are in. The data has been collected, and the conclusion is a brutal indictment of the world we have inherited. The Egyptian system, which treated women as legal and economic partners, fostered a society of breathtaking longevity and internal stability. The European system, which reduced women to property and breeding stock, institutionalized a culture of perpetual conflict, endless warfare, and deep structural inequality that haunts us to this very day. Consider the legacy of ancient Egypt. For 3,000 years, it remained a remarkably cohesive and stable culture. It had its dynastic struggles, its foreign invasions, its periods of chaos. But the underlying social fabric, the day-to-day life of its people, was uniquely resilient. Why? In part because by giving women a full stake in the economy, it created a society with a vastly larger base of stakeholders. A woman who owned her own land, ran her own business, and could protect her assets in court was not a threat to social order. She was the social order. She was a taxpayer, an employer, a contract signer. She had as much invested in the stability and prosperity of her community as any man. This system diffused economic power, made property more fluid, and lowered the stakes of marriage. Marriage was a partnership, not a high-stakes diplomatic merger that could trigger a war if it went wrong. The relative internal peace of Egypt was not an accident. It was the logical outcome of a more just and inclusive social design. Now consider the legacy of Europe. The feudal and post-feudal model, built on primogeniture and the commodification of women, did not create order. It created a permanent state of latent warfare. The entire political history of Europe, from the fall of Rome to the 20th century, is a story of endless, bloody conflict over inheritance. The 100 Years' War was fundamentally a dynastic dispute, a fight over a claim to the French throne that was passed, ironically, through a female line. The Wars of the Roses, the 30 Years' War, the War of the Spanish Succession. Look beneath the surface of almost any major European conflict, and you will find a marriage contract, a disputed dowry, a tangled family tree. By turning women into the conduits of power but denying them any power themselves, the system made their wombs the battleground of empires. The very legal architecture designed to consolidate power in the hands of a few men guaranteed that those men would be eternally at each other's throats. This model of exclusion had consequences that reached far beyond the battlefield. It created a template for oppression. By institutionalizing the subjugation of women, European society perfected the intellectual and legal tools for creating another. The logic used to justify coverture was the same logic used to justify serfdom. The arguments for why a woman could not be trusted with property were easily adapted to argue why a peasant, a Jew, or a colonized native could not be trusted with freedom. The system was a blueprint for hierarchy, a masterclass in how to justify the power of a chosen few over the disenfranchised many. Uncomfortable. Quote, from the fictionalized work of a modern historical sociologist, Dr. Eris Thorne, in his book, The Inheritance of Violence. We have for centuries analyzed the causes of European warfare in terms of economics, religion, and national ambition. We have missed the engine under the hood. The legal disempowerment of women was not a peaceful sidebar to this history. It was its primary engine. By creating a system where the only path to acquiring new land and power was through conquest or a strategic marriage, the European aristocracy eliminated all other options. In this zero-sum game, violence and diplomacy by marriage were the only two moves on the board. A more equitable distribution of property, inclusive of women, would not have created a utopia, but it would have created a society with more shock absorbers, more stakeholders, and fewer reasons to settle every dispute with a sword. The meta-commentary is this: we are the direct heirs of this legacy of institutionalized conflict. The deep-seated inequalities, the idea that society is a brutal competition for scarce resources, the reflex to solve problems through domination rather than partnership. These are not universal human truths. They are the specific cultural and psychological inheritance of a system that began with the fundamental error of excluding half of humanity from power. The Egyptian experiment, for all its faults, suggests that a different path was possible. A path based on balance, not domination. But that path was abandoned, the memory of it erased. We have been living with the consequences ever since. For 1,000 years, the lie had been safe, buried under the weight of a carefully curated history. The story of progress, of the steady upward march from the darkness of the ancient world to the enlightened modernity of the New Age, was the foundational myth of Western civilization. And by the 19th century, in the heart of the great European empires, this myth had become an unshakable religion. The Victorian gentleman with his steam engines, his telegraphs, and his globe-spanning armies looked back on the ancient world with a mixture of romanticism and pity. They were a people of superstition, of primitive laws, of moral infancy. We, the men of the modern world, were their superiors in every conceivable way. It was the age of Darwin, of industrial power, of absolute, unshakable self-confidence. And it was at this exact moment of peak arrogance that the sands of Egypt decided to return the things that had been stolen. The discovery was not made in the tomb of a great pharaoh. It did not come from a golden mask or a royal decree. It came from the garbage dumps. In the late 19th and early 20th centuries, archaeologists working at sites like Oxyrhynchus began to unearth hundreds of thousands of fragments of papyrus. This wasn't the literature of the elite, it was the paperwork of ordinary people, the bureaucratic trash of a lost civilization, preserved for 2 millennia by the dry, sterile sand. They were tax receipts, private letters, shopping lists, and, most importantly, thousands upon thousands of everyday legal documents, marriage contracts, divorce settlements, property deeds, lawsuits, and last wills and testaments. As the first generation of papyrologists began the slow, painstaking work of translation, they found themselves staring at a world that should not have existed. Their own wives, sisters, and daughters back in London, Paris, and Berlin were living under the shadow of coverture and the Napoleonic Code, legally barred from owning property, signing contracts, or in many cases, even controlling their own wages. And yet, here on these brittle 2,000-year-old scraps of paper were women from a primitive pagan civilization conducting business with a freedom that was, to the Victorian mind, simply unthinkable. They read the will of Naunachta disinheriting her children. They read the marriage contract of Arsinoe, with its massive financial penalty for a divorcing husband. They read the court plea of Heria, demanding the return of her donkey and speaking with her own mouth. It was like finding a fully functional microchip inside a dinosaur fossil. The evidence did not fit the narrative. It broke the timeline. It was a ghost from a murdered past, returning to haunt the very people who had built their world on top of its grave. This discovery should have triggered a revolutionary reassessment of history. It did not. For many historians, the cognitive dissonance was too great. The evidence had to be explained away, minimized, or dismissed as a symptom of a morally decadent and chaotic society. Uncomfortable. Quote, from the fictionalized private journal of Sir Alistair Finch, a prominent British legal historian, circa 1895, have spent the week reviewing the translations from the new Egyptian finds. It is utterly perplexing. We are presented with legal contracts that appear to grant married women a degree of financial autonomy that would rival a man's in our own city. They buy, they sell, they lend at interest. One is forced to wonder if we are translating these texts correctly. If the translations stand, then one can only conclude that the Egyptian social order was a deeply disordered and unnatural thing, a society without the proper God-given hierarchy of the family. It is little wonder that their civilization ultimately fell. Such a system, which elevates the woman beyond her natural station, contains the seeds of its own destruction. It is a historical curiosity, certainly, but not a model to be admired. The meta-commentary is about the sheer power of a buried truth. The unearthing of the papyri was the single most important event in the secret history of women. It was the recovery of the primary evidence. It proved, with the cold, hard finality of 1,000 legal documents, that the Great Regression was real. It proved that the fight for women's rights in the 19th and 20th centuries was not a radical demand for a new, imagined future, but a desperate attempt to reclaim a lost, documented past. The lie of linear progress, the single most powerful piece of propaganda in the patriarchal arsenal, had been exposed by the garbage of a forgotten people. The story was not over, but for the first time in over a millennium, the counter-evidence was no longer just a whisper. It was a mountain. And so we arrive at the present, or something resembling it. We stand in the rubble of a fallen world, holding the dusty papyrus fragments in one hand and the cold, hard text of modern law in the other. And we are forced to confront the final, and perhaps most uncomfortable truth of this entire story. The great, heroic, and world-changing struggle for women's rights over the last 2 centuries, the movement we call feminism, was not a radical act of invention. It was an act of archaeology. It was a desperate, bloody, and often blind attempt to dig through 1,000 years of accumulated lies and manufactured history to reclaim a civilization that had been buried alive. The suffragettes chaining themselves to railings were not demanding a strange new future. They were fighting, whether they knew it or not, for the rights of a woman who lived in Thebes in 1200 BCE. Every single battle of the first and second waves of feminism was not about creating new rights, but about dismantling the specific legal cages that had been built during the Great Regression. Think of the Married Women's Property Acts of the 19th century. They were a direct frontal assault on the doctrine of coverture. Their goal? To give a married woman the right to own property in her own name, to control her own wages, and to sign her own contracts. This was not a radical new idea. It was a desperate plea to be treated with the same legal respect as a female brewer on the banks of the Nile 3 millennia earlier. The fight for divorce reform? The long battle to allow a woman to leave a marriage without being cast into financial and social ruin? It was a fight to dismantle the sacramental prison built by the church and restore the simple contractual exit strategy that was once a given. The fight for the vote, for a political voice, was an attempt to regain a fraction of the agency that had been stolen. The fight for access to education and the professions was a war against the legacy of the guilds and the Aristotelian lie that a woman's mind was unsuited for the real world. At every turn, these women were told they were unnatural, that they were rebelling against God, history, and biology. They were told they were trying to invent a new kind of society that would lead to the collapse of civilization. And all the while, the proof that their radical new world had already existed and had thrived for millennia lay sleeping under the sand. They were fighting in the dark, armed only with a burning sense of injustice, unaware that they had a mountain of historical precedent on their side. They had been so thoroughly robbed of their own history that they did not know they were the rightful heirs to a lost kingdom. And their opponents, the defenders of the patriarchal order, wielded this historical amnesia as their most powerful weapon. Uncomfortable. Quote, from a fictionalized editorial in a London newspaper circa 1910 by an influential anti-suffrage member of parliament, the shrill demands of these so-called suffragettes represent a fundamental misunderstanding of history, nature, and the very fabric of our Christian civilization. For 2,000 years, the progress of man has been built upon the stable foundation of the family, a unit in which the man, by his very nature, is the head, the protector, and the public representative. To grant the vote to women would be to invite the chaos of the boudoir into the halls of parliament. It is an attack on an order that has been settled since the time of the Greeks and sanctified by our Lord. It is not progress. It is a regression into a kind of primitive, sentimental anarchy. It is, in short, a declaration of war on history itself. The irony is so profound it is almost physically painful. He accuses them of waging a war on history, when they were its true, forgotten defenders. He holds up the 2,000 years of patriarchy as proof of its naturalness, completely blind to the 3,000 years that came before it. The meta-commentary, the final word, is this: the Great Regression has not ended. The legal cages have been largely dismantled, yes, but the psychological architecture, the deep cultural programming that taught the world a woman's word is suspect, her ambition is unnatural, and her independence is a threat, that remains. It is the ghost in the machine. It is the reason for the pay gap, for the double standards, for the unconscious bias that still shapes our world. The greatest triumph of this 1,000-year campaign was not the laws it passed, but the lie it embedded in our souls. The lie that women were asking for something new. They were not. They were, and still are, simply demanding the return of stolen property. The fight for progress is a myth. It has always been a fight for recovery, and that's the truth they tried to bury. We look back at this immense, deliberate regression, and it's easy to feel a sense of despair. The sheer scale of the theft, of rights, of wealth, of history itself, is staggering. The core of this story, the uncomfortable paradox, is that the official narratives handed down to us are rarely complete. They are edited for comfort, curated to flatter our sense of modern superiority. While the specific quotes and internal memos in this dossier were synthesized to cut through the noise, the historical trajectory is brutally, undeniably real. A world was lost, not by accident, but by design. We are still living in the shadow of that loss, still fighting to reclaim the ground that was once a given. So we encourage you to take this history and share it. Look at the world around you, at the debate still raging, and ask yourself, are we truly progressing, or are we just remembering? Until next time, always question the official story.